Swayam Prabha. Digital India. Educated India.
Namaskar. Welcome to the lecture series of Minor Act. In this lecture series, we are going to explore the legislations which are referred as the minor acts, not because they are insignificant, but because they are small, focused, short, and based on the specific legal theme. Along with these discussion on minor acts, we will also explore the two more acts which are very relevant and crucial for the law students, aspirant, and the legal practitioners. And these acts are the Advocate Act and the Contempt of Court Act 1971. Now, in today's lecture, this is our lecture number 1 in this lecture series. We are going to start our discussion on the very first act, the Indian Stamp Act 1899. Have you ever wondered that how a legal document become legal? How a document or a piece of paper get a legal validity? The answer of all these questions is lie in our today's discussion. Our today's discussion is, as I said, on the Indian Stamp Act 1899. Let us begin. You can see on your screen, there is pictures, stamp duty or Indian non-judicial. This is a stamp. And today, our complete discussion of this 1 hour is on and around these stamp duty. The topic which we are going to cover today is, we'll discuss the outline, the introduction of this act, objective of the Stamp Act 1899, and then we understand some common instruments, and then we'll discuss chapter number 1, chapter number 2. So our discussion in today's lecture will be till section 1 to section 19. See, the Indian Stamp Act 1899, it received its assent on January 27, 1899, and it came into force on July 1st, 1899. So total we have 8 chapters, 78 sections, and 1 schedule in the Indian Stamp Act 1899. Let us understand the background and introduction of this act. The Indian Stamp Act 1899 is the fiscal statute which is designed to collect the revenue for the government through imposition of stamp duty on various legal and commercial documents. So this lecture provides an in-depth look at the Indian Stamp Act, and we will cover the key definitions, the extent of the liability, the mode of using stamp, the time of stamping, and valuation of stamp duty, who pay the stamp, etc. So as already mentioned in the previous slide, this complete act is divided into 8 chapters, and then there is a 1 schedule. In Hindustan Steel Limited versus Dilip Construction Company, in 1969, the Supreme Court held that the Stamp Act is fiscal measure enacted to secure revenue for the state on certain classes of instrument. So basically this act is collecting the revenue for the state. And that's why this act ensures that the legal and commercial documents, they are duly stamped, providing the legitimacy and legal enforceability while generating the significant revenue for the government. Now, what are the purpose of this act? What are the objective of this act? So the main purpose or objective is to generate revenue for the Indian government. So a document that is stamped act as a valid evidence in the court of law. So once the document is stamped, it is considered valid evidence in the court of law. So Stamp Act also make payment of stamp duty on some documents compulsory, which in return make those documents legally valid and authentic. So it means that once the document is stamped, means some documents where the stamp duty is compulsory, only after giving that stamp duty or levying that stamp duty, the document become valid. So ultimately, this also prevent fraud by ensuring the documentation. And then it also create a uniform legal framework for documentation, for record keeping, and also in respect to the property, contract, financial instrument, and commercial dealings. So what are the common instruments which we will cover? The sale deed, the gift deeds, lease agreements, mortgage deeds, power of attorney, partnership deed, and share certificate. All these terms we are going to discuss in our discussion in this act. Now let us begin with this sale deed. Let us understand that what is this sale deed, because in our lecture all these terms come across number of times, so it's better that we understand this in the very beginning of the lecture. See, sale deed. There is one Mr. Amit, he want to buy a residential plot from Ravi in Shimla, and that is for the 50 lakh rupees. So 50 lakh is the consideration for this. What is the consideration? The 50 lakh rupees is consideration. So Amit want to buy a residential plot from Ravi in 50 lakhs. Now a sale deed is drafted and all required clauses are signed by both the parties. So Amit and Ravi, they drafted a sale deed. Both the parties, Amit and Ravi, they signed it. Now let us assume that stamp duty rate in Himachal Pradesh is 6%. So the stamp duty for 50 lakh multiply 6%. Now this will be 3 lakh rupees. And registration fee approximately, if it is 1%, then it will be 50,000. So sale deed is executed, means signed and registered with the sub-registrar. We will discuss this further in the Registration Act also. And after registration, legal ownership is transferred from Ravi to Amit. Now, the 2 or 3 important point here in this discussion is that there is a kind of a sale deed between A and R, and this sale deed is in consideration of 50 lakhs, and both the parties, they sign. The sale deed is executed, signed, and then it is registered in the sub-registrar office, and in this way there is transfer of ownership. So legal ownership transferred from Ravi to Amit, because he buy the plot, so this legal ownership is transferred. So what does it mean? That here the right on the property is created and there is a transfer of property. Now, if this sale deed between Amit and Ravi is not stamped, or if it is not registered, it will be considered inadmissible in evidence in court in under section 35 of the Indian Stamp Act. Further, it will be invalid for transferring ownership, and it attract the penalty up to 10 times the deficient duty. Section 40 will deal with this. Now let us take one more example. Ramesh wants to gift his residential flat worth rupees 40 lakhs in Delhi to his daughter Priya. So because gift is a gift, there is no consideration if there is a gift deed. Now the hypothetical situation said that a father wants to gift his flat to his daughter. The value of the flat is 40 lakh rupees. Now further, there is a legal deed which is prepared and stating that Ramesh is gifting his flat to his daughter Priya, right? Now in Delhi, this gift of immovable property to a family member like a daughter or a son, it attract concessional stamp duty. And for example, the 1% of the market value plus surcharge, and stamp duty will be 40 lakh multiply by 1%. So it will be 40,000. It will be 40,000. Now, separate from stamp duty, for example, 1% in some states are fixed. So the deed is executed and it is registered in the office of the sub-registrar. Once this is registered, then ownership legally transferred to the priya. But here in this gift deed, there was legal document which is prepared, but consideration is missing. There is no consideration in a gift deed. There is no consideration in a gift deed. So because this document is registered now, the deed is executed and registered in the office of sub-registrar, this gift deed is valid. But for the validation of this gift deed need to be duly signed by, executed by the parties, and it need to be stamped. It need to be stamped. So if gift deed is not duly stamped and registered, it is legally invalid and it will not be considered as an evidence in the court of law, and it may result penalty and fine under section 35 and section 62 of Stamp Act. Now let us take one more example of a lease agreement. So Sunita wants to lease out her commercial shop in Chandigarh to Meena for 5 years. For time, 5 years. Monthly rent 25,000 with an upfront premium of 2 lakh rupees. Now see here, stamp duty calculation will be like the places there in Punjab or Chandigarh. So we'll consider the rate from that state only. So monthly rent is 25,000. We'll multiply this by 12, multiply by 5. Now this will be 15 lakh because this is for the 5 years, and this will be yearly, and this is for 5 years. Now what is the premium? Premium she's asking for 2 lakhs. So total consideration is 17 lakh, and stamp duty, if it is 2% of the total consideration, it will be go 34,000. So assuming that the state charges 2% of the commercial lease agreement, registration fees will be 1,000, which is actually fixed by the local authority, and then on that the fees which will levy on the 34,000. This is the stamp duty which will be on the document. That what are the legal implications of non-compliance in lease agreement? Now, if this is not stamped, then the lease agreement is inadmissible as an evidence. If not registered, then this lease is legally invalid and it cannot be enforced in a court of law. And if it is wrong stamped, means the value which is paid is wrong, then subject to the penalty up to 10 times the amount of the deficient stamp duty, and it may delay the registration and affect the enforceability of the document. And same is the case in mortgage deed, where we discussed this Vikram borrowed 10 lakh rupees from ABC Bank, and then he execute a simple mortgage deed on his house in Lucknow. So this deed include detail of the borrower, the lender, the loan amount, and the repayment terms and the property description. Now let us assume that in Uttar Pradesh the charges is 2% upon the loan amount for a simple mortgage. Then it will be, stamp duty will be on 10 lakh multiply by 2%, and stamp duty will be 20,000 rupees. So same registration fees is also payable in the sub-registrar's office, and deed is signed and registered to make it legally enforceable. So if it not stamped, the same thing happened. Deed is inadmissible as an evidence, and this the party may impose up to 10 times the deficit, section 40, and if not registered, this mortgage become invalid, and if the loan is over 100 rupees, then the lender cannot enforce right through the court proceeding. So while we discuss all these instruments, there is a one thing common among all these, whether it was a gift deed or a sale deed or a mortgage deed. All these documents create rights, liabilities. They created the limited, extended, or extinguish or recorded, or they create a transfer of the documents. So these sale deed, gift deed, mortgage deeds, all these documents, they are known as instruments. They are known as instrument. Now let us begin with the chapter number 1. Section 1, very quickly we'll discuss the short title, extent and commencement of this act. The title of this act is Indian Stamp Act 1899. So we understand that this act come into existence, it was enacted in 1899. Now subsection 2, extend to whole of the India. So as we have to read this as per the language of the act, proviso that it shall not apply to the territories that before 1st of November 1956 they were the Part B states. The Indian Stamp Act 1899, now it is applicable to whole of the India, including the state of Jammu and Kashmir and Union Territory Ladakh. Now when we see subsection 3, commencement, it shall commence into force on the 1st of July 1899. Now despite its age, this act still remains operative and is still serving its purpose of collecting revenue for the state government. Section 2, it deals with the definition or the key definition. So in this lecture, I am only going to discuss the few important definition we have in section 2. Now let us see. Section 2, clause 14, it discusses instruments. So I already give you idea that what amount to be the instrument, but let us read that what is the definition of instrument in the act. Any document, so the sale deed, the gift deed, the mortgage deed, the lease agreement, all these are the documents by which any right or liability is or purports to be created, transferred, limited, extended, extinguished or recorded. We call these are the instruments. So the government notify certain instruments that will not be treated as instrument for the purpose of stamp duty. So it means that there might be some document which the state government exempted just to levy stamp duty on them. So such exemptions, they are published in the official gazettes. Moving further, I already mentioned that the sale deed, the gift deed, mortgage deed, lease agreement, partnership deed, etc., they all are the instruments. Now, one more addition here in this discussion of the instruments. Nowadays, in modern financial instrument, it also covers the digital document, especially on stock exchanges with depositories like NSDL, CDSL. So these digital document relating to shares, debentures, securities, etc. So it extended to any other document which is listed in Schedule 1 of the Act. For example, the bond, conveyance, promissory note, power of attorney, and insurance policies, etc. This clause 26 discusses the stamp duty. This is very important. The stamp duty. What is now stamp duty? So first of all, let us understand what is a stamp. Stamp means any mark. Now what is this mark? This mark is a kind of a seal. This mark is a kind of endorsement. So mark, seal, endorsement by any agency or a person who is duly authorized by the state government, and it include adhesive or impressed stamp for the purpose of duty chargeable under this act. So a stamp duty is, this is the tax which is paid to the state government on certain documents to make them legally valid, acceptable in the eye of law. We call this is a stamp duty. Now mark, seal, endorsement means any visible sign or impression that is indicating the stamp duty. So it may be physical when you printed or affixed a seal, or it may be digital. Under modern e-stamping system, it is digitally, we call that this is a e-stamping, digital stamping. So who is the person? As the language of the definition said, any agency or person. So only those entities or officials who are notified in the official gazette by the state government, they are considered as the agency, and only they are authorized to affix the seal. And who are these officers? Maybe the Treasury Officer, Sub-Registrar, the Stock Holding Corporation of India for e-stamp. Now, For the stamp duties, let us understand that there are two types of stamps: impressed stamps and adhesive stamps. So impressed, the term itself give you the meaning that this stamp is embossed or it is engraved on a paper to denote duty. So a stamp that is engraved or printed directly on the paper. So this is a stamp paper. The stamp is there. We call this is impressed stamp. Like for example, the court fee stamp, the stamp paper I mentioned here, the court fee stamp or the stamp paper, they are known as impressed stamp. Now let us see what is the adhesive stamp. So a stamp which is printed on a piece of paper, the small stamps printed on a piece of paper and affixed on the document. So a stamp that is purchased and affixed on a document, we call that notarial stamps, the revenue stamps, these are known as the adhesive stamps. So impressed stamps and adhesive stamps are the two types of stamps. Now let us see what clause, how clause 11 2, section 2, clause 11 define what is the duly stamped. So if we know that what is a stamp, the two types of stamp, duly stamps mean an as applied to an instrument, that instrument which wears an adhesive or impressed stamp for of not less than the proper amount, and such stamp has been fixed or used in accordance with the law for the time being in force in India. So duly stamped mean when an instrument is properly stamped. So it may be adhesive stamp or it may be impressed stamp, but this stamp is not less than the amount, the proper amount which is supposed to be affixed on that document. So the stamp duty which pay must be equal to or more than the amount which is prescribed under the Schedule of Indian Stamp Act. So the stamp must be properly affixed or printed. It may be purchased from any authorized vendor or maybe from any agency. Now let us take one example on duly stamped. See, a sale deed of rupees 20 lakh in Delhi is executed. Executed means it is signed on stamp paper worth rupees 1 lakh at 5% of rate, and it is properly registered. So if it is properly registered, we call this is a duly stamped. Sale deed of 20 lakhs in Delhi, it is executed on a stamp paper of worth rupees 1 lakh, and then when it is properly registered, now we can say that now the document is duly stamped. Now everything, all the formalities has done. Now this is the duly stamped. Now what happens if the document is not duly stamped? So the same deal is executed on a stamp paper worth rupees only 50,000. This is not a duly stamped because the stamp duty on this paper is 1 lakh rupees. But if the stamp duty is only which is executed, the sale deed is if executed on the stamp duty of 50,000, then we'll say that it would attract a penalty if it is not duly stamped, and it may be inadmissible under section 35 of Indian Stamp Act 1899. Moving further, section 2 clause 10 explain what is conveyance and what it include. They said it include a conveyance on sale and every instrument by which property, whether movable or immovable, is transferred inter vires and which is not otherwise specifically provided by the schedule. So conveyance on sale means a document executed to transfer ownership of property from seller to the buyer for a consideration. Price means, so it's a sale deed. Every instrument, any legal document that affect a transfer of the ownership or interest of the property. Property may be movable property may be immovable property. So it may be machinery, the vehicle, maybe the land, maybe the house, maybe the agricultural land, or it may be building. Intervise means transfer must take place during the lifetime of transferor and transferee. Now, it is not inherited because it is there in a testamentary document. So, it is not by inheritance or by will. So, this is conveyance, and then to subclause 12, it define executed and execution. Now, till this discussion, we understand that executed means when the document is signed, and execution is, this is the act of signing the document. So we say that a document is executed means when it is signed by both parties, and execution is, this is about signing a document. We call this is the execution. Now, to clause 17 discuss what is mortgage deed. So mortgage deed, it includes every instrument whereby for the purpose of securing money advance or to be advanced by way of a loan or an existing or future debt, the performance of an engagement, one person transfer or create to in favor of another, a right over or in respect of specified property. I already give you one example on the mortgage deed, right? So mortgage deed, this is an instrument. This is used for to secure a loan or maybe debt by transferring or creating a right in favor of lender over a specified property. Now this clause 16, it define lease. Lease means a lease of immovable property. And this lease also include a patta, kabiliyat or a written undertaking not being a counterpart of a lease. And it also include an instrument by which the tolls of any descriptions are let, any writing of an application for a lease which is signifying that application is granted. So a legal contract where one party, that is a lessor, give the right to use his or her immovable property to another, that is a leasee, for a certain time with or without rent, we call this is lease. So all documents are treated as leases and are chargeable with stamp duties under Article 35 of Schedule 1 of the Indian Stamp Act 1899. So stamp duty depend on duration of lease, amount or of rent or premium, or what is the nature of the property, whether it is residential or commercial property. And then the state specific amendment is also important for the stamp duty. Promissory note. Promissory note, a note which is defined in Negotiable Instrument Act 1881. I'm sure all of you already have a very good understanding of the Negotiable Instrument Act 1881, and you understand that what is the meaning of promissory note. So here we'll discuss that this include the payment of any sum of money out of any particular fund, or which may or may not be available upon any condition or contingency, or which may or may not be performed or happen. So what are the important point? That a promissory note under the Indian Stamp Act, what it include? Unconditional written promises. For what? To pay money. Then a promise to pay out of the specific fund. Then a promise which is conditional on an event or even in if uncertain. Now what are the requisite of a promissory note? As per the Negotiable Instrument Act 1881 are, the document must contain unconditional undertaking. Undertaking must be to be paid money only. Money to be paid, it must be certain, and it must be payable to or to the order of certain person or to the bearer. Now see one example here. An instrument in the form of I do acknowledge myself to be indebted to B in rupees 10,000 to be paid on demand for value received. This kind of a note is known as promissory note. Now let us see chapter 2 of Indian Stamp Act 1899. I divide this chapter into 5 parts. The liability of instruments to duty, the modes of using stamps, the time of stamping instrument, what will be the valuation of the duty, and duty by whom. So section 3 to 30 of the Act, it deal with the part 2 of the Stamp Duty Act. Now let us begin with the very first part, the liability of instruments to duty. Section 3 to section 9 of this Act deal with what are the liability of instruments to the duty. Section 3, instrument chargeable with the duty subject to the provision of the Act and exemption in Schedule 1. The following instruments are chargeable with stamp duty to the amount indicated in the schedule. So whatever is the amount indicated on the schedule, the stamp duty will be accordingly. Now see what clause A said. It is executed in India. Now every instrument mentioned in Schedule 1 which had not been previously executed by any person. So this instrument which is not previously executed by any person, and is executed in India or on or after 1st July 1899. 1899. So a sale deed of immovable property signed in India after 1st of July 1899 is chargeable with stamp duty under this clause A of section 3. Clause B said foreign promissory note or bill of exchange. So every bill of exchange or promissory note drawn or made outside India on or after 1st of July 1899, but which is accepted, paid, presented, endorsed, transferred or negotiated in India, that will be eligible for the stamp duty. So let us take one example. A foreign promissory note drawn in the UK, but it is presented for payment in India. Now this is chargeable with duty in India. Clause C, other instrument executed abroad. Every instrument excluding the bill of exchange or promissory note, if they are executed outside India after 1st of July 1899 and which relate to the property which is situated in India or relate to any act done or to be done or is received in India, then they will be also covered under this section 3, where the stamp duty will be applied. Example, a power of attorney executed in the US to manage property in India, in Delhi, and received in India is charged under the Stamp Duty Act. Now, there is one proviso to section 3, that what are the instruments which are not chargeable. So it means that the instrument in clause A, B, C, they all are chargeable with stamp duty in India, but then there is some exemption to this. And exemption 1 is instrument executed by or for government. So no stamp duty on instrument executed by, for or in favor of the government if the government would otherwise be liable to pay. Let us take one example. A contract agreement which is signed by the government department, this is totally exempted from the stamp duty. Exemption 2 is on the ships or vessels transfer document. So no duty on instrument for sale, transfer, mortgage or disposition of any ship vessel or part, share, interest in any ship that is registered under the Merchant Shipping Act of 1894 UK. Now we'll take one example for this also. For example, a document transferring share is a registered Indian ship is not liable to stamp duty. Exemption 3 is about no duty on an instrument executed by or on behalf or in favor of the developer or unit or in connection with carrying out of purposes for special economic zone. So the instrument which are executed in reference to the special economic zone, they are also exempted from the stamp duty. So section 3 is the charging section of the Indian Stamp Act of 1899. This section basically identify the instrument become liable to the stamp duty, and it also provides a specific exemption for the government and ship related documents which are exempted from the stamp duty. Now, so far section 4 is concerned, several documents in one transaction. Let us give a reading to subsection 1. If multiple instruments are used to complete a single transaction, means sale, mortgage, settlement, then there is multiple instrument, but they are used to complete a single transaction. So instruments are multiple, but transaction is single. So only the principal instrument is chargeable with the full stamp duty as per schedule 1. The other instrument, they are the supporting or the secondary instrument, they are chargeable with a very nominal duty of ₹1 instead of the full duty. Now, sometimes one transaction is, split across the multiple document. For example, sometimes one transaction is split across the multiple document. So, to avoid the double or excessive taxation, only the one main principal document pay the full stamp duty, and all other associated document at the same transaction, they attract only ₹1 duty. Subsection 2 discuss choice of principal instrument. So the parties can decide among themselves which instrument can be treated as a principal instrument. So, and the proviso of this subsection is the instrument chosen as the principal must bear the highest applicable duty among all the involved documents. So it is not like that person he is doing a single transaction for multiple documents and he is choosing the one document on which he has to be pay a very less stamp duty. So the provisor said that among those instruments, the person will choose the instrument as a principal document which must bear the highest applicable duty among all the documents. So basically this section 4, it ensures that a single transaction is documented in multiple parts. Only one document pay the full stamp duty and other only a nominal 1 rupee. Right? Now moving ahead, see the document involved a sale deed, transferring property, stamp duty 1 lakh, possession letter confirming handover, payment receipt acknowledging payment of the sale price, affidavit by buyer regarding the possession. Now the stamp duty for sale deed, principal instrument 1 lakh rupees, others 1 each, possession receipt, affidavit, all these are the documents with this sale deed. So what is the principal document? The sale deed is a principal document. So this possession letter, the payment receipt, the affidavit, these 3 are the other document with this sale deed. So sale deed, principal instrument 1 lakh. So total stamp duty will be on 1 lakh, and then these 3, 1 plus 1 plus 1, this is the 1 lakh and 3 rupees. I'm sure how you understand the section 4. Section 5, instrument relating to several distinct matters. Now there was a single transaction, but the different documents were there. But section 5 discuss instrument relating to distinct matters. Now the matters are different. Though we just see that here the document involved all these possession letter, payment receipt, affidavit, they all are in connection to this sale deed. But section 5 said that instrument relating to several distinct matters. So the matters are different. And what is the language of this section? Any instrument comprising relating to several distinct matters shall be chargeable with the aggregate amount of the duties with which separate instrument each comprising or relating to one of such matter would be chargeable under this act. So if a single document deals with 2 or more completely different matters, for example, the sale and a gift or a mortgage and a lease, then the document is treated as if 2 or more separate instruments were executed, and if it happened, then for each document there will be separate stamp duty. Give a look on this example. The stamp duty will be calculated separately for each matter. So the total duty payable, sum of duty of each distinct matter. Now see example, sale plus gift in one deed. A single deed, one deed, or a part is gift, part is mortgage. Sell property A to person X. Sale is of 50 lakhs. Gift property B to person Y. Gift is of 10 lakh. So stamp duty implication is duty on sale. Duty on sale 5% of 50 lakhs, 2,50,000. Duty on gift 4% of 10 lakh, this is 40,000. So the total stamp duty here will be 2,90,000 rupees. Now if we give a comparison between section 4 and 5, in section 4 if we see that there are the several instruments used in single transaction, but here instrument is there, but it is relating to the several distinct matter, and hence only principal instrument pay fully duty, other pay 1 rupees, and here pay full duty on each distinct matter mentioned. So there is multiple instrument, there is a single instrument. Now the single instrument is covering the multiple matters, but multiple instruments, they are for one transaction only. So moving further, section 6, instruments coming with several description in schedule 1. Now this is a very detailed section. You can read, subject to the provision of the last proceedings of sections, an instrument so framed as to come within 2 or more description in schedule 1 shall, where the duty chargeable thereunder are different, be chargeable only with the highest of such duty. So there is one instrument which is so framed, and that instrument fall in any two categories of the schedule of the act. And if it is so, then we have to be see that what will be the stamp duty. So the provision section 6 said, shall where the duty chargeable thereunder are different, be chargeable only with the highest of such duty. So provided that nothing in this act contain shall render chargeable with duty exceeding 1 rupees or counterpart or duplicate of an instrument chargeable with the duty. So we can say that if an instrument is framed in such a way that it fit in two or more categories which are listed in schedule 1 and different duties apply to that different categories, so the one to which the stamp duty is higher, only that duty will be applied, higher will be chargeable on that document. Moving further, there is one exception to this also, a counterpart or duplicate of any instrument. Now for which a proper duty has already been paid will not be charged more than one. So let us take one example, gift plus settlement. A document appear to be both a gift of a property to a relative and a family settlement also. So a stamp duty on higher of the two. So gift deed or a settlement, whose whatever is higher, the stamp duty has to be paid on that. Now next is example of a duplicate document. As I said that a counterpart or duplicate of any instrument for which the proper duty has already been paid will not be charged more than 1 rupee. So the person is looking for the duplicate document, looking for the duplicate document. So the person is looking for the duplicate document. A duplicate lease deed is created for record keeping only. So if the person is having the original lease deed is already bear full stamp duty, then if the person want to get a duplicate one, only fee payable is ₹1 for that. Section 8 discuss bonds, debentures or other security issued on loan under the Local Authority Act 1879. Again, this section is important. We see that Section 8 of Indian Stamp Act provide for the concessional treatment for stamp duty in respect of the bonds, debentures or other securities issued by the local authority when they raise loan under the Local Authority Act of 1879. So subsection 1 said charging duty at concessional rate. So a local authority like a municipal corporation or panchayat, when they are raising a loan under the Local Authority Act by using the bonds, the debentures, securities, is required to pay a stamp duty at the rate of 1% of the total amount of the securities issued. So 1% of the total amount of the security issued. So these securities need not to be individually stamps. They will not attract any further duty on the renewal or consolidation or subdivision or any other transaction related to them. Subsection 2 said retrospective application and validation. See, bonds and securities already issued before the law, they come into force, including these, those unstamped will be considered valid. So the 1% rule will be applicable to the existing bonds too. And such securities are exempt from the being re-stamped. So this is, however, if the duty was due before 26th March 1897, has not been paid or remitted, it must still be paid. Subsection 3 talk about penalty for non-payment. Again, the subsection 3 of section 8 is important. Now what happened if the stamp duty is not paid? So if a local authority willfully neglect to pay the stamp duty, penalty will be 10% of the total amount. Let us take one example. The Municipal Corporation of Chandigarh issued bond worth ₹100 crores. Stamp duty 1% of the 100 crore, that is a 1 crore. So these bonds need not be individually stamped. The ones they stamped for 100 crore, the stamp duty is a 1 crore. Now these bonds, they don't need to be individually stamped, and no further stamp duty will be required if these bonds are further renewed next year, or bonds are split into smaller denominations, or bonds are consolidated in fewer or larger bonds. Section 8A discuss the security dealt in depositories not liable to stamp duty. Now this section provides exemption from stamp duty for certain security related transaction involving depositories. See, issue of securities to depositories. So when a company issuer, they issue the securities to depositories, for example, the NSDL or the CDSL. Stamp duty is only paid to the stamp duty is only paid on the total amount of the security issued, and there is no need to stamp the individual securities. What is the benefit? The benefit is that this is a time saving, and it is also cost in the demat process. So basically this is facilitate the bulk electronic issuance. So that's why this is really a good initiative. Clause B said issue of the certificate of security. So if a company issue a physical certificate under section 14 subsection 3 of the Depository Act 1966, it will be liable for duty as applicable to duplicate certificate. So this maintain parity between the physical and demat for duplicate issues. Further, transfer of ownership. Transfer involving the dematerialized securities, and they are not liable to stamp duty. So transfer of registered ownership from a person to depository or from a depository to the beneficial owner, they are not liable for the stamp duties. Now let us take one example. Exemption of stamp duty on securities in demat form. For example, there is one ABCD limited company, and company issue the 1 lakh equity shares. Now instead of issuing the physical share certificate, ABC Limited issue them in demat form through NSDL depository. So as per section 8A, ABC Limited will pay stamp duty only once in the total value of 1 lakh share which is issued to the depository. So there is no need to affix the physical stamp duty on each demat share. So further, section 8B, it discusses corporatization and demutualization schemes exempt from the stamp duty. Yes, when a recognized stock exchange is corporatized or demutualized as per a SEBI approved scheme, then stamp duty is exempted. If when there is an instrument, that is agreement, deed or document, when it is executed in connection with the corporatization or demutualization, including the transfer of property, assets, contract liability, etc., even in such situation, instrument, they are not liable to pay the stamp duty. Section 9 discusses the power to reduce, remit or compound stamp duties. So this section empowers the government, central state government, depending on the subject, either to reduce or cancel the stamp duties, either fully or the partially. When this applies such a reduction, prospectively for the future or retrospectively for the past. So subsection 1 said, what are the government powers? They said the government may through a rule or order which is published in their official gazette, remit, reduce the stamp duty on either all the instruments or any particular class of the instrument, for example, the sale deed or the mortgage, or maybe the instrument executed or in favor of a particular class of person, that may be the SC, ST or NG, or it may be any kind of a startup. What is the composition or consolidation of duty? See, when we discuss composition or consolidation of duty, it allows companies to pay a consolidated amount of stamp duty in bulk. For what? For insurance policies, for debentures, for bonds, for market securities, for other marketable securities. So, it transfer of such instruments, even if transferee is a private person, right? And then this also avoid stamping each individual document separately. It will otherwise create a lot of burden. Subsection 2, meaning of government. This is simple. The central government for bill of exchange, checks, promissory notes, transfer of shares, debenture, and all stamp duties falling under NT 96 of list 1, that is union list. So far the state government is concerned, you can see all other instruments, sale deed, lease, all fall in the state list in the constitution. So let us take one example. Himachal Pradesh, they have decided to reduce the stamp duty for the starters for encourage the innovation and investment. So we take one more example, that in Maharashtra in 2024, stamp duty on the property which is registered reduced 1% for the property if the property is registered in the name of woman. So if the normal stamp duty is a 5% of a property worth of 50 lakh, a woman wire, that is the stamp duty will be only 4% on that 50. So section 10 talk about duties, how to be paid. Subsection 1 said modes of paying the duties chargeable on instrument must be paid through the use of stamps unless the act specifically provided or otherwise. So this may happen if the provision is already there, express provision, then they are directed by the state government through its rule. So in simple term, we can say that stamp duty must be paid either by affixing the appropriate act or as directed by the state rule. When the rule can be regulate, subsection 2 discuss in the following aspects: description of stamps, what kind of stamps can be used of each type of document, number of stamps, how many stamps can be used on a document, size of a paper, especially relevant for the bill of exchange or the promissory note, that what will be the size of the paper, and then law can prescribe the paper size to avoid the fraudulent insertions. So that is also important here. Further, section 11 discuss use of adhesive stamps. Now this section specify where the adhesive stamps can be used instead of impressed or e-stamps. Adhesive stamps are used in otherwise than impressive or e-stamps. So adhesive stamps, we know that they are physically stamps that are affixed, pasted on the document, and they can cancel to indicate the stamp duty has been paid. So this is a adhesive stamp, and it need to be cancelled, like crossing it, maybe half on the stamp and half on the paper. So they are commonly seen on the affidavit, the power of attorney, or in the stamp papers, or in the entry of advocate, shared transfers, etc. Section 11A discuss the low duty instrument chargeable with duty not exceeding 10 naya paisa. And clause B discuss the bill of exchange, promissory note, they are drawn or made outside India. For example, if a promissory note made in the UK, presented in India, it can be validated using the adhesive stamp. It can be validated using the adhesive stamp. Clause C said entry of an advocate, vakil, attorney on the roll of High Court. When an advocate is enrolled in the High Court, an adhesive stamp is fixed on his enrollment form or document. Then notarial acts. Example is when a notary public certificate, a document, adhesive notarial stamp, 10 or 20 rupees is pasted and cancelled on that. Further, clause E discuss transfer of shares by endorsement in any corporated company or body corporate. So all adhesive stamps must be cancelled at the time of execution, that is by signature, initial stamping device. Section 12 discuss cancellation of adhesive stamp. Again, this is an important provision. This section lay down the mandatory procedure for cancelling adhesive stamps to prevent their reuse or ensure that stamp is properly accounted for. This is a simple provision which discuss that the purpose of cancellations only to ensure that once a stamp is used to pay a duty, it cannot be reused to pay the stamp duty. So just to avoid the reuse of the stamp duty, it need to be cancelled. So section 12 talk about this. Further, section 13 discuss the instrument stamped with impressed stamps, how to be written. So every instrument written upon paper stamped with an impressed stamp shall be written in such a manner that stamp may appear on the face of instrument and cannot be used for or applied to any other instrument. So the provision ensure that impressed stamp paper, that is a paper on that already bearing a stamp duty, printed or embossed on them, are used exclusively and properly for the purpose document intended for, right? So that stamp duty cannot be misused or it cannot be evaded. So we can see one example. If a sale deed is drafted directly on a 100 rupees impressed stamp paper, the full text start on the same sheet and stamp is visible at the stamp is visible at the top. So the instrument continued on additional sheet if needed. But if the paper impressed with the 100 rupees stamp is remain blank and the sale deed is started on the additional sheet, then it will not be considered the genuine sale deed. Section 14, only one instrument to be Section 14, only one instrument to be on same stamp. Section 14 mandate that only one principal instrument that is chargeable with the stamp duty can be written on a single paper of a stamped paper. Now this ensure that proper assessment of the stamp duty is possible. No double use of the stamp will be taken place, and it also avoid the revenue loss for the state government. Now, there is also exception to this rule, but this section allow the certain endorsement even on an already stamped instrument. See example of allowed instrument. Suppose a promissory note is executed on a duly stamped paper. Later, the endorsee write on it that he has received a payment in full. Then this endorsement is connected to the original instrument, and it does not require a new stamp if exempt or is duly stamped is allowed under section 14. Time of stamping instrument, section 17 to 19 deal with the time of stamping instrument. So section 17 deal with instrument executed in India. So whatever instrument executed in India, it must be stamped at or at the time of the execution. Let us quickly give a look on the example. A sale deed of a land is signed in Delhi. It must be properly stamped paper before or at the time of signing. If stamped after execution, it is invalid. When it need to be stamped before execution, it is invalid for legal purpose unless validated after a penalty. So if it is validated after the executed, then the parties have to pay the penalty for that. 18 discuss the instrument executed outside the India. Now the instrument is executed outside the India. Now this is not including the bill of exchange and notes. So any instrument executed outside India and not a bill or a promissory note, it can be stamped within 3 months. Now they have given the reasonable time period that if the instrument is executed outside the India, then the 3 months reasonable time period is given for stamp duty. So a lease agreement executed in London on 1st of June reaches India on 15th of June. Now it must be stamped before 15th of September. So that is the 3 months time period. 18 to discuss the collector's help. So if the proper stamp cannot be fixed privately, maybe due to some type or a format, so the person can take the document to the collector's office within the 3 months to pay the duty and get it officially stamped. And section 19 discuss the bills and notes drawn outside India. Now for the bill of exchange, not payable on demand of course, and the promissory notes which are drawn outside India, the first holder in India must affix the correct stamp. Cancel it before any of these actions. What? Presenting for acceptance or payment, endorsing, transferring or negotiating, right? So take one example. A promissory note is made in New York. It is brought to Mumbai. Before the first holder present it for the payment or transfer it, they must affix and cancel the proper Indian stamp for the same. So this is about section 19. Proviso said safe harbor clause. Now if the bill already have a proper adhesive stamp which is affixed and cancelled as per section 12 and the holder has no reason to suspect the fraud, then the stamp is deemed to valid for that holder, and penalty cause if the current holder is protected, the original party who failed to stamp it properly may still face the penalty. So that's all about the introduction, the objective of the act, and the discussion on the time of stamping instrument, the liabilities of on the instrument stamp duty. So that's all for lecture number 1. We'll continue discussion on the Stamp Duty Act in the lecture number 2 of the Stamp Duty Act 1899. Thank you.
Hello and welcome to this piece of literary snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.